Australia visa changes in October 2025 have produced a wide-reaching reshape of policy that impacts students, skilled migrants, temporary workers, employers and families. And the following plain language paragraph summarizes the main directions and practical implications for applicants and sponsors across all major visa streams while offering clear guidance on how to adjust plans for migration to Australia in the new policy environment. The Australian government has adjusted migration planning levels and priorities so that places in the permanent migration program have been redistributed with a stronger emphasis on skills innovation and regional settlement, and these changes mean that applicants with high demand skills or demonstrable records of innovation and entrepreneurship now have a comparatively clearer pathway to permanent residence compared with earlier priority regimes. The new talent and innovation category has been introduced to consolidate pathways for global talent and distinguished talent applicants and to provide targeted places for those who can contribute to research commercialization and national innovation priorities, which creates an opportunity for founders, researchers and senior technology specialists to seek fast-tracked consideration, but it also raises the bar on evidence and endorsement. So applicants should prepare robust documentation of patents, publications, funded projects and commercial outcomes. The skills in demand visa has superseded the older temporary skills shortage arrangements, and this change affects the way employers nominate overseas workers and their criteria that applicants must meet to be granted temporary work rights under employer sponsorship. Under skills in demand, employers are expected to demonstrate stronger workforce planning evidence, including advertising and local recruitment efforts, and they must meet updated market salary thresholds that align with the government goal of protecting local wages and reducing exploitation. For lower paid roles, for skilled migrants who relied on the previous subclass structures, applicants should check whether their occupation remains on the consolidated skilled occupation list, because the lists have been updated and certain occupations have been added while others have been removed or relocated between national and regional lists. This update means some applicants may need new skills assessments or alternative nomination strategies, such as securing state or territory nomination or moving to regional employer sponsorship for specific streams, so that some visas now accept a wider set of accredited English assessments while other streams have tightened minimum scores, particularly where applicant roles are highly client-facing or safety-critical. As a direct result, applicants and agents must verify acceptable tests and score thresholds before booking assessments, since previous assumptions about acceptable test providers may no longer hold. The student visa landscape has been reshaped by policy commitments to manage overall student intake and to increase fees for student visas as part of a broader approach to cap growth and to ensure quality compliance by education providers. Larger fee increases have been proposed, which will affect future cohorts, and institutions may be required to meet enhanced quality metrics for recruitment and student support to continue recruiting overseas applicants. This means prospective students should budget for higher visa costs and choose providers with a demonstrable record on compliance and graduate outcomes, because these factors will influence visa and post-study work outcomes. Post-study work rights have been adjusted with clearer direction on how recent graduates can transition to work pathways and eventually to permanent residence. The changes include extended recognition of local work experience gained on student and graduate visas, and more structured pathways for graduates in priority occupations, such as health, aged care, engineering, and advanced digital technologies. For recent graduates, employers and applicants should document employment contracts, references and payslips carefully to build credible claims for skilled experience and future nominations. Regional migration incentives have been clarified and expanded to encourage settlement outside major metropolitan centers, and this includes additional nomination points and processing priority for applicants willing to live and work in designated regional areas. The intent is to rebalance population growth and to support industries in regional labor shortage areas. Applicants considering regional nomination should verify designated postcodes and livability commitments and be prepared for compliance. Visits or follow-up checks from regional authorities. The family stream remains important, but their planning levels have been kept demand-driven so that partner and child visa processing will still depend on broader program capacity, and integrity checks have been strengthened to detect sham arrangements and to ensure sponsor obligations are met. Employers who sponsor overseas workers should be aware that the compliance framework has been tightened with increased penalties for non-compliance and for misuse of the sponsorship framework. This includes stronger auditing of labour market testing evidence and more frequent reviews of nominated roles and salary levels. Employers must ensure that sponsored workers are paid market rates and that workplace conditions meet modern award requirements or risk serious sanctions, which could include being excluded from sponsorship programs for multiple years. The government has also moved to streamline processing for priority sectors by introducing digital tools and an enhanced employer liaison system that aims to reduce delays for critical skill nominations. Humanitarian and temporary protection arrangements have been adapted to respond more flexibly to international crises, but they streamlined arrangements for emergency temporary visas do not automatically create a direct permanent protection pathway, which means humanitarian applicants should seek legal advice about eligibility and long-term options, and in other cases, ministerial instructions have clarified how existing applications will be treated, so it is critical to check the specific instrument relevant to the visa subclass before making decisions about travel, employment or study. The updates to salary thresholds, employer obligations and labour market testing mean that visa costs and the total cost of sponsoring a worker have climbed, and both sponsors and applicants should budget for higher fees and potential recruitment expenses and for the cost of legal or migration advice where the case is complex. The regulator to suspend or cancel registrations where poor practice is identified and to restrict new enrollments where integrity risks are evident. Applicants should therefore check provider standing with the regulator and seek credible reviews before enrolling or signing contracts. The overall message for applicants is to prioritize accuracy, evidence, and planning, and to avoid assuming that previous acceptance criteria remain unchanged. Applicants should perform a mapping exercise for their circumstances against the latest skilled occupation lists and migration program planning levels, and if needed to seek state or territory nomination or a regional employer sponsorship route, they should contact relevant nominating authorities early. The new emphasis on innovation and high-level skills means that experienced professionals with a demonstrable track record of results should prepare curated dossiers including project summaries, published work patterns, and evidence of commercial or community impact to maximize chances on the talent and innovation stream. For those relying on employer sponsorship, it is essential to confirm that sponsoring employers meet the updated sponsorship standards and that nominations include the required labour market testing evidence, residents with clear records of paid employment and tax contributions. The department will publish further instrument-level detail. Department of Home Affairs guidance. Check the current skilled occupation lists and migration program planning levels and obtain professional migration advice for complex cases to ensure alignment with the new rules and to avoid costly mistakes when applying for visas under the updated framework.